welcome to all. As a part of the course Insolvency and Bankruptcy Law in India, today we are going to discuss who can initiate the insolvency proceedings under IBC code. In the last class, we have discussed various definitions under Insolvency Bankruptcy Code. Today we are going to discuss who may initiate insolvency proceedings, CIRP, and how to initiate insolvency proceedings by financial creditor. So before discussing who may initiate, let us discuss the flowchart, how CIRP will follow. Whenever there is a default is there, which is above 1 crore rupees, the minimum triggering point for default is 1 crore rupees. That is, if the corporate debtor fails to pay 1 crore or more, then in such cases there is a default. Then application can be filed to NCLT by the financial creditor, operational creditor and corporate debtor themselves. So who can initiate the CIRP process? Financial creditor. There are three categories are there: financial creditor, operational creditor, corporate debtor themselves. So they have to make an application to the NCLT. So NCLT will verify. We are going to discuss in the subsequent lessons what to verify. The checklist is there, what to verify, how to verify, everything we are going to discuss. Okay. So NCLT will verify. Then within 14 days, they are going to admit the application, or else they are going to reject the application. Whenever they are rejecting the application, they are supposed to give the explanation, reasons for the rejection. So once it is admitted by the NCLT, National Company Law Tribunal, once the application is admitted, then they are going to appoint the IRP, Interim Resolution Professional. So in case if the application is made by the financial creditor, the interim resolution professional shall be mentioned. The name of the interim resolution professional shall be mentioned in the application itself. Whereas operational creditor, he may or he may not mention. Corporate debtor, he has to mention the name of the interim resolution professional. Then once the interim resolution professional is appointed, then the powers of the board of directors is going to be suspended. That means the interim resolution professional, that is resolution professional, is going to replace the board of directors. Once the CIRP process is started, then moratorium will be effected. As per section 14 of the IBC, moratorium will be implemented. In the subsequent lessons, we are going to discuss what is moratorium, what is the scope of moratorium. In a simple language, for the time being, I can say that moratorium means during the CIRP process, no one can file a suit against the company. So which suit can be filed, which suit cannot be filed, what can be stalled, what cannot be stalled, everything we are going to discuss in the subsequent lessons. Okay. Then within 30 days tenure, IRP will do the following. So what he is going to do? He is going to do the public, he is going to go for public announcement. Then he is going to collate and verify the claims. So if any creditor is having any claims, so through public announcement, he will invite the creditors to submit the claims. Once the claims are submitted, he is going to collate and verify the claims. Then he is going to constitute committee of the creditors, COC. Simply we will call it as committee of the creditors, COC. Then committee of the creditors, they are going to hold the first meeting. Okay, in the first meeting, IRP will appraise the COC. Then IRP will return. So interim resolution professional will return. Please remember, IRP will be there in the picture from the date of application to the NCLT, once it is admitted, till the COC takes charge. So subsequently, once the COC came into picture, then they are going to appoint resolution professional. Please remember, this IRP may continue as a resolution professional. So there is no bar. So possibility is there, you may appoint another person as a resolution professional, or else you may continue with the IRP. That is possible. That is up to the discretion of the committee of the creditors. Then once the resolution professional is appointed, he is going to manage the affairs of the corporate debtor, including the compliances. Please remember, till now it is the responsibility of the board of directors to manage the compliances in a company. Now it is because resolution professional is replacing the board of directors, so that's why it is his responsibility to manage the entire as a going concern. He is supposed to manage the company. and even for the compliances also he is a responsible person. Then check the legitimacy of the resolution plan and present the same before COC for voting. So what he is supposed to do? Before that, actually he is supposed to appoint the valuer, so and preparation of information memorandum. So he is supposed to assess the assets of the company. So what is the value of the assets? Okay, so everything he is supposed to prepare. So in that process he can appoint various professionals, because single person cannot manage the entire company, so he can appoint various persons. So these valuers, they'll give the valuation report, based on which he is going to give this valuation in the public announcement. Then he is going to invite the creditors to give the claims. Once the claims are given, then he is going to verify the claims depending on the books of accounts. Based on the books of accounts, he is going to verify the claims. Then he is going to update the claims register. Okay, then he is going to make the public announcement for expression of interest. So once everything is done, then he is sure about, or he is aware of, what is the assets of the company, what is the liability of the company. Because unless he is able to arrive at the claims and valuation of the company, he cannot invite the people, or he cannot invite any resolution applicant to give the application. Okay, so he is going to make the public announcement for expression of interest. Okay, then once the resolution plans are submitted by the resolution applicants, then he is going to verify the legitimacy of the resolution plan, because there are certain categories of the people who cannot submit the resolution plan. In the subsequent lessons we are going to discuss who is eligible to file resolution plan, who is not eligible to file a resolution plan. The resolution plan will be placed before the COC. Then if the COC approves the resolution plan, then we are going to make an application to the NCLT for its approval. Please remember, NCLT is not going to verify the commercial wisdom of the COC. So if the resolution plan, suppose if the haircuts are more, then NCLT will not verify. Okay, NCLT will only verify whether while approving the resolution plan, did they follow the law or not, did they follow the procedure or not. That is what they are going to verify. Okay, their NCLT role is to verify the legal formalities. Okay, then once the COC approves the resolution plan, then they will approach the NCLT. Before NCLT, you are going to make an application. So in case if there is no resolution plan, or no plan is approved, no one is willing to purchase the company, or else no resolution plan is approved by the COC, then you can approach the NCLT for the liquidation. Okay, then that is the second part of our sessions, where we are going to discuss about the liquidation. Okay, so other faculty is going to discuss about the liquidation in the subsequent lessons. Okay, this is the total overview. Okay, so you are going to make an application, then application is admitted by the NCLT, then a resolution professional will be appointed, then he is going to take over the management of the company, then he is going to prepare the assets and liabilities, then he is going to parallelly he is going to conduct the committee of the creditors meeting, and in the committee of the creditors meeting, this IRP will be replaced by the resolution professional. Maybe same person may be appointed as the resolution professional. Then he is going to verify all the data, he is going to prepare the data of the company, then he is going to give a public announcement, he is going to make an invitation to the public investors, probable investors, to give the resolution plan. These resolution plans will be placed before the committee of the creditors. Committee of the creditors will approve it. If they don't approve it, or if you don't receive any resolution plan, then NCLT will give the order for liquidation. So the liquidation is the second part in our sessions. Okay, in our lessons. Now let us discuss the governing sections of IBC Code 2016. Part 2 of the IBC Code deals with the insolvency, resolution and liquidation for corporate persons. Let us see what is there. In part 2, section 6 deals with the person who may initiate CRP. So already we have discussed who may initiate CRP. So CRP may be initiated by the first category financial creditor, operational creditor or corporate debtor. Then section 7 deals with the financial creditor. So how to make an application by the financial creditor is discussed under section 7 of the Act. Then section 8 and 9, both the sections deals with the operational creditor. So how operational creditor, they shall make an application to the NCLT. So that is discussed under section 8 and 9. Then section 10 deals with the corporate applicant. So if the company itself, if they want to make an application for CIRP process, then how to make an application, that is discussed under section 7. Then let us discuss who can initiate. As already we have discussed, in case of default, so please remember the default amount must be more than minimum 1 crore rupees, more than 1 crore rupees. Okay. So in case of a default, who are entitled to initiate the CRP? Financial creditor, operational creditor, and corporate debtor himself. Okay, so these three categories of the people, they can initiate the CIRP. Now let us look at the section wise. Okay, section 6. Section 6 of IBC provides that where any corporate debtor commits a default. So the term default is very, very important. Already we have discussed the definition. Today we are going to discuss a few judgments also. Okay, so commits a default, a financial creditor, an operational creditor, or corporate debtor itself may initiate CRP in respect of such corporate debtor in the manner provided in the chapter 2 of part 2 of the code. So as already we have discussed, part 1 is preliminary part. Part 2 deals with the corporate insolvency and liquidation of the company. Okay, so in the manner that is prescribed in this chapter. Now let us see. Now another one question mark may come into the picture. Okay, so we can initiate the CRP process against the companies. So is it possible to initiate the CRP process against the government company? Why? Because if you observe the Constitution of India, government companies are considered to be instrumentality. They are considered to be state. They are defined to be state. They will come within the definition of the state under the Constitution of India. Now, can you initiate the case against the government company? The court. We may be under the impression that because it is considered to be state, no one can initiate the liquidation proceedings or insolvency proceedings against the government. But in the case of Harsh Pinge versus Hindustan Antibiotics Limited, in this case, NCLT Mumbai held that. So though it is a government, though it is considered to be an instrumentality of the state, but for the commercial purpose, actually it is also a government company. So we are categorizing the company into government company because minimum not less than 51% of the share capital is held by the government. So here government can be either state government or central government as defined under the Companies Act. Okay, so merely because the government is having the share capital in the company, it does not mean that it is not regulated, it is not controlled by the IBC, because as already we have discussed to whom this legislation is applicability of the legislation in the previous slides, in the previous lessons. Company is covered by the IBC, that is company is regulated by the IBC. So government company is also company. Okay, so that's why government company, against the government company, you can initiate the CRP process. In another case law also, Central Inland Water Transport versus Brijonath Ganguly. It's Ganguly, it's not Ganguly, it's Ganguly. So in this case law also, NCLT held that yes, you can initiate the proceedings against the government company. Now, who is a financial creditor? Because we are discussing the financial creditors today. So under section 7 of the IBC, financial creditor can initiate the CRP process. So section 7 lays down the procedure for initiation of the corporate insolvency resolution process. Now from now onwards, I will call it as a CIRP process. For our convenience sake, I will call it as CRP process. Okay, so CRP means corporate insolvency resolution plan process. So the CRP process by the financial creditor or two or more financial creditors jointly. Okay, so the section 7 application can be made by the one creditor or two or more financial creditors jointly. Then what are all the essentials to be satisfied, to be established for admission of corporate debtor? So whenever if you are filing a case against the corporate debtor for initiation of CRP process, there are certain essentials to be satisfied. First essential, there must be a debt. Unless there is a debt, you cannot file a case. Okay, so what is the meaning of debt? It is given in the Webster in the case of Webb versus Stenton. In this case law, learned Justice Lindley, he defined debt as a sum of money which is now payable or will become payable in the future by reason of present obligation. So that means presently you are having some obligation. So because of this obligation, it is becoming payable right now. Maybe it is becoming payable right now, or it is becoming payable in the near future. So it becomes payable now, or it is becoming payable in the near future, okay, because of some present obligation, okay. So then that is called as debt. So first essential to be satisfied is debt. Then having the debt is not sufficient, please remember, okay. There must be a default, okay. So I'm having an obligation to pay, but if I fail to pay, then only you can exercise the right against me, okay. So there must be a default within the period of limitation. So please remember here limitation act is applicable, okay. So whenever there is a default is there, generally if you are supposed to recover any money from someone, you are supposed to file the case within a period of 3 years, okay. So this period of limitation is applicable. Then the amount of default should be above the threshold limit, okay. So if you observe this legislation, the threshold limit is 1 crore rupees. So what are all the essentials to be satisfied if you want to file an application, or if you want to admit an application under this code? 3 essentials must be satisfied. First one, there must be a debt, and it must be a default, and the amount of default should be above the threshold limitation, that is minimum 1 crore rupees, okay. Then the definition of financial debt is given under section 5A. Please remember, when financial creditor wants to file a case or wants to file a application under this section 7, it should be financial debt, okay. It's not only debt, it is a financial debt, okay. So already we have discussed in the previous lessons, we have discussed the definition of financial debt. So that is defined under section 5 subsection 8 of the act. So if you observe section 5 subsection 8, which provides that under section 5 subsection 8, dispersal should be to the corporate debtor. So if you observe the first line of the section 5 subsection 8, okay, it must be disbursed, okay. They use the word dispersal. So what is the meaning of dispersal? Okay, so I have to give the money to the corporate debtor, okay. So in the Supreme Court, in the case of Pioneer Urban Land Infrastructure Limited versus Union of India, okay, so in this judgment they have explained, okay, the definition of financial debt states that the debt must be dispersed. So first of all, there should be a debt, and it must be dispersed against the consideration for time value of the money, okay. So there should be some time value of the money. So now let us discuss, okay, so what is the meaning of disbursement? Already we know what is the meaning of debt. Now what is the meaning of disbursement? Disbursement includes, okay, so the departing of money from the creditor. So from the creditor to the debtor, the money must be departed. So the money must be transferred from creditor to the debtor, and it is available upon such departure. Please remember, once it is departed from the creditor, if it is not available to the debtor to use it, then that is not disbursement, okay. Disbursement means, suppose if I am receiving some money, the money should be available for my utilization, okay. So its availability upon such departure is required. Then if these two conditions are satisfied, it is called as disbursement. So that means, when I can call it as a disbursement means the money should move from creditor to the debtor, and the money should be available to the debtor for his usage, okay. Then it is called as disbursement, and the disbursement must happen for the time value of the money. So what is the meaning of time value? Time value means the price associated with the length of the time that an investor must wait until an investment matures or the related income is earned. So time value of the money means, in a simple language, today I am having 10 rupees, okay, I have invested. If I have to wait for some time, so maybe after 1 year, 2 years, the value of the money will increase, obviously, okay, because as the economy is going, as the economic activity is going on, obviously generation of the surplus is one of the major requirement of any business entity, okay. So anyway, so time value of the money means the price associated with the length of the time, as the time is going on, okay. So it will have some value, okay. So an investor must wait until an investment matures or the related income is earned, okay. So this is the meaning of time value of the money. Now how to initiate? First we will look at the definition, we will look at the section 7 in detail. Then subsequently we will try to discuss each and every point in detail, okay. So let us look at the definition, let us look at the section 7. Section 7 speaks about initiation of corporate insolvency resolution process by the financial creditor. Okay, so section 7, enabling the financial creditor to initiate the CRP process. Now let us subsection 1, the financial creditor either by itself or jointly. So please look at the word, the financial creditor either by itself or jointly. So that means even joint application can also be made. We will discuss in detail. With the there is a subset with other financial creditors or any other person on behalf of the financial creditor as may be notified by the central government may file an application for initiating the corporate insolvency process against the corporate debtor before the adjudicating authority when a default has occurred. If you look at this definition, okay, so we have to underline certain points. Financial creditor either by itself, that means alone or jointly. So the application can be made by the financial creditor, single financial creditor, or else jointly, two or more people. Okay, so other financial creditors or any other person on behalf of the financial creditor. So financial creditor may authorize someone else. Okay, so that authorized person also can file. Okay, may file an application for initiation of CRP against the corporator before the adjudicating authority. So he himself or with jointly he can file an application for CRP process before whom, before the adjudicating authority when a default is there. Okay, so in the last classes we have discussed what is the meaning of default. When there is a default is there, then you can file an application under this section. Now let us look at it. Provided that for the financial creditor referred in clause A and B of subsection 6A of section 21, an application for initiation of CRP against the corporate debtor CD shall be filed jointly by not less than 100 of such creditors in the same class or not less than 10% of the total number of such creditor in the same class, whichever is less. So this is recently inserted. Okay, so by virtue of this section, by virtue of this provision, okay, so it's not that always one creditor can file the case or jointly. There is a possibility, okay, if any class of creditors are there. Okay, actually this was inserted to protect the interest of the home buyers. Okay, so based on the recent judgments given by the Supreme Court has given various judgments. Home buyers are considered to be financial creditor within the meaning of this legislation. Okay, so we are going to discuss the judgment part subsequently. Okay, why home buyers are considered to be financial creditor, what is the reason behind it, we'll discuss it subsequently. Okay, so these home buyers, okay, they can, because they are considered to be a separate class. Okay, so this class of creditors may be 100 members. Okay, 100 creditors. Okay, or else 1/10 of the total value. Okay, total credit 1/10 of the value, they can file an application under this section. Okay, so whereby this proviso is enabling you or is enabling the class of creditors to file an application under this section. Okay, now provided, let us look at the provision. Provided further that the financial creditor who are allottees under the real estate project, an application for initiation of CRP process against the corporate debtor, that is CD, shall be filed jointly by not less than 100 of such allottees. So minimum 100 members are there, or else not less than 10%. Okay, so whichever is less, they can make an application. Then provided also that where the application for initiation of CRP against the CD has been filed by the financial creditor referred in first or second proviso and has not been admitted by the adjudicating authority, okay, before the commencement of Amendment Act 2020, because in the year of 2020 only these provisions were inserted. Okay, such application shall be modified to comply with the requirements of first or second proviso within 30 days. Okay, so through this Amendment Act 2020, the central government has enabled the home buyers to be considered as financial creditor and they can file an application under section 7 of the act. So they can file an application under this section and within 30 days they can make the necessary changes accordingly. Okay, now explanation. For the purpose of this section, a default includes default in respect of financial debt owed not only to the applicant financial creditor but also any other financial creditor of the corporate debtor. So it means that when I am saying that default, so why it is so important? As already we have discussed, there should be default and the default amount must be 1 crore. When I am saying that 1 crore, possibility is there one creditor is having 90 lakhs. I mean one creditor's debt value is 90 lakhs. So he is not satisfying 1 crore. So we are not going to consider this person alone. Okay, so together, if any other creditor is there, together if you are exceeding the triggering point, that is more than sufficient. Okay, so which is enabling you to file a joint application. Okay, the financial creditor shall make an application under subsection 1 in the such form as may be prescribed. Okay, today we are going to look at the form level also. Okay, what is the form to be filed with the RO, with the NCLT, everything we will see. Okay, then the financial creditor shall, along with the application, what to be furnished? Record of default, recorded with the information utility. So one of the essential condition is that there should be a debt and it should be default. So we should provide the evidence whether the default is there, the debt is defaulted or not. Okay, so that's why you have to submit the record of default. Okay, so how to submit the record of default, we'll discuss it. Okay, so the record of default recorded with the information utility or such other record or evidence, as may be specified. Then the name of the resolution professional. Please remember, whenever you are making an application under this section, you are supposed to give the name of the resolution professional. Okay, proposed to act as an interim resolution professional. Subsequently, this person may act as a resolution professional. Okay, at present you are proposing him as interim resolution professional. Once the application is admitted by the NCLT, once the COC is formed, then COC may appoint you as a resolution professional, or they may appoint other person as a resolution professional. Okay, so the name of the resolution professional must be mentioned in the application. Okay, and any other information as may be specified. Okay, because we are having rules and regulations. Okay, so IBBA is going to specify the rules and regulations. As per the rules and regulations, you are supposed to give such other information as may be prescribed. Okay, then once it is done, you have made an application. Okay, then the adjudicating authority within 14 days from the date of application under subsection 2 ascertain the existence of the default from the record of an information utility or on the basis of evidence furnished by the financial creditor. So that means within 14 days the adjudicating authority shall ascertain the existence of default. That means he should decide whether there is a default is there or not. Once there is a default is there, then he can admit the application within 14 days. So the section, if you observe, the adjudicating authority shall, they have used the word shall, but by the Supreme Court it was not interpreted as shall. Okay, though the time limit, the section uses the word shall, it means that the adjudicating authority shall admit the application within 14 days, but Supreme Court in various judgments, okay, so we are going to discuss those judgments. In various judgments, it was stated that here we may interpret it as a may, not shall. That means there is a discretionary powers are there to the adjudicating authority whether to accept it, whether to admit the application or not to admit the application, reject the application. Okay, provided that, okay, so if the adjudicating authority has not ascertained the existence of default, suppose after looking at the application he is of the opinion that there is no default, okay, then pass an order under subsection 5 within such time and it shall record its reasons in writing for the same. So what they are saying, once if you make an application for the CIRP process, the adjudicating authority will verify the document. Based on the document, he came to the conclusion that there is no default. Okay, in such cases he may reject it. When he is rejecting, please remember he has to give the reasons for the same. Okay, then where the adjudicating authority is satisfied that okay, default is there, then a default has occurred and the application under subsection 2 is complete and there is no disciplinary proceedings against the proposed resolution professional. Okay, so one of the checklist that has to be observed by the NCLT is that there should be default, and when the financial creditor is proposing the resolution professional, against the resolution professional there shall not be any disciplinary proceedings. If any disciplinary proceedings are there or pending against the resolution professional, NCLT will not allow such professional to act as an IRP. Okay, then default has not occurred. Suppose if the default has not occurred or the application under subsection 2 is incomplete or any disciplinary proceedings are pending against the proposed IRP, okay, then they may reject the application. Okay, so clause A dealing with the acceptance of application, clause B is dealing with the rejection of application. Okay, so if checklist is satisfied, there is a debt is there, there is a default is there, and no proceedings are there against the resolution professional, then tribunal will accept it. Okay, or if any of these three conditions are not satisfied, debt, default, proceedings, okay, they are not satisfied, then in such cases tribunal will reject the application. Okay, so provided, let us look at the section subsequent. Okay, provided that the adjudicating authority shall, before rejecting the application under clause B of subsection 5, give a notice to the applicant to rectify the defects. Please remember, he cannot reject the application just like that. Okay, so whenever NCLT is rejecting the application, okay, the court cannot reject it like that. Okay, so whenever NCLT is rejecting the application, they shall give an explanation, they shall give a chance to the applicant to rectify the mistake. Suppose there are some errors are there in the application, then NCLT shall give an opportunity. Okay, so he shall give an opportunity to the applicant to rectify the mistake. Okay, if any defects are there, he can rectify. Then within 7 days, it should happen within 7 days. Okay, rectify the defect in his application within 7 days of the receipt of such notice. Okay, now 7 days notice is given. Then the corporate insolvency resolution process shall commence. So once it is admitted, the CIRP process is started. Okay, that is called as commencement date. Then adjudicating authority, once it is started, he shall communicate the order to the financial creditor and the corporate debtor. So immediately the order must be given to the financial creditor and corporate debtor stating that resolution process started now. So the order under the above subsection, okay, to the financial creditor within 7 days of the admission. Okay, so when you are supposed to give the order, within 7 days you are supposed to give the order to the financial creditor. Okay. In today's lesson, we have discussed about CIRP flowchart, where we have discussed who can initiate CIRP process, when the application is admitted by the adjudicating authority, then what is the consequences, like how moratorium is fixed, then how interim resolution professional is going to be appointed. Then once the interim resolution professional is appointed, he is going to give the public announcement. Then COC will be formed. Then subsequent to that, once the COC is formed, then resolution professional may be appointed. Then subsequent to that, he is going to receive the claims. Then he is going to collate the claims. Then he is going to invite the prospective resolution applicants to give the resolution plan. Then resolution plan they are going to discuss. Then COC is going to approve the resolution plan. Once that is done, then resolution plan will be implemented. Otherwise, if COC fail to approve any resolution plan, then NCLT will give the order for liquidation of the company. So the CIRP flow chart we have discussed in today's lesson. Then subsequent to that, we have discussed governing sections like section 6, who can initiate. It speaks about who can initiate CIRP process. Then section 7, initiation of CIRP process by the financial creditor. Section 8 and 9, CIRP process by initiation of CIRP process by operational creditor. Section 10, by the corporate debtor. We have discussed section 6, 7, 8, 9 and 10. Then we have discussed who can initiate CIRP. Then before that, before discussing the who can the initiation of CIRP process by the financial creditor, we have discussed about the essentials to be satisfied or essentials to be established for the admission of corporate debtor. So when I want to initiate CIRP process against the corporate debtor, we need to satisfy certain essential conditions. These essential conditions we have discussed in today's lesson.